I was reading through what Don had to say and looking at some of the maps. I couldn't help but think about a lot of the feverish, hallucinatory things we've been hearing from our national government about being invaded by those people, those brown people from south of the border. And as it turns out, they're about 3 or 4 centuries too late to panic about our continent getting invaded. And Don is going to tell us about that. So have a seat, everyone, and get ready to listen. Okay, Don.
Some of you know I always wear a lot of special t-shirts. Several years ago, there was a car in the faculty parking lot at the college where my wife taught. It read, the only Indian problem, a poor immigration policy. Today I'm going to survey immigration and immigration policy in North America through 1965. Part 2, which I believe is next week, starts with a major change in U.S. law and policy that takes us up to the present. It has become a moving target on a daily basis. I admit to a West Coast, primarily California perspective. Therefore, our story does not start with the traditional tale about a Dutchman who claimed ownership of an island in a river after giving a few trinkets to an indigenous individual living there. Nor does it start with whoever Pocahontas met after a ship landed in what is now, I believe, Virginia, or the religious zealots whose ship tied up by a rock west of Cape Cod. Instead, we will start by looking at who else from the Eastern Hemisphere showed up in North America and the lands they claimed and settled. I will not start at the very beginning, the theory that Western Hemisphere was first inhabited by Asians crossing a land bridge into Alaska many millennia ago. And upsetting my former Ballard neighbors, I will ignore Leif Erikson, this group that got to Newfoundland around the year 1000, even though his statue stands prominently along the waterfront at the Shilsha Marina. Sorry, Karen. Christopher Columbus was not Spanish, but an Italian working for the Queen, never reached the mainland of North America. However, he and his successors soon occupied Cuba and other islands as well as much of South America. They moved out from there. Well, now first in time, I would like to start with Hernan Cortez. With all due respect to Mr. Keats, I do not know whether Cortez was stout, but most certainly he did not go to Panama and never saw the Pacific Ocean. In the spring of 1519, Cortez sailed from Cuba to Cozumel, finding some hostility among the locals on the island. Perhaps it was spring break, there were no vacancies available. He then went to the mainland of Yucatan and found a Spanish man who, as they say, had gone native. He had learned the local dialect and was one of several who started to dilute the indigenous bloodline. With a small entourage, including indigenous women, Cortez then headed through the Gulf of Mexico to a small island just offshore of what is now Veracruz. 2 years later, Spain had conquered Mexico. Thus began what one writer referred to as the Great Biological Exchange. From this start, Spain expanded its empire northward into all parts of what are now California, Nevada, Utah, Arizona, New Mexico, and Texas, as well as parts of Wyoming, Colorado, Kansas, and Oklahoma. By 1610, he had founded Santa Fe, New Mexico, it had, not Cortez, he was long gone by then. And I have distant relatives by marriage that trace their presence in Trinidad, Colorado back to a few years later. And they even used Spanglish as the playground language in the mid-20th century. Some of my fellow students at my high school in Fullerton, California, still lived on land grant ranches given to their ancestors centuries ago. Fullerton College is on what was still a Basque land grant ranch until well into the 20th century. The largest of the land grant ranches still intact at that time was the Irvine Ranch. It was in a vast, largely roadless area at that point. Let us now return to the East Coast, starting near the Bay of Biscayne. Ponce de Leon landed in Florida in 1513, claiming it for Spain. Eventually, the Spanish got as far as South Carolina and still kept Florida and parts of Alabama, Mississippi, and even Louisiana along the north shores of the Gulf of Mexico into the early 19th century. These were not the only Spanish incursions. They also went up the Mississippi, founded New Madrid and Cape Girardeau in modern Missouri. At one time, they even controlled much of what became the Louisiana Purchase territory, even though the French dominated much of that region most of the time before we acquired it. This map is from a book which I recommend. This is a library copy I read it years ago but didn't bring it with me, called El Norte, the epic and forgotten story of Hispanic North America. This gives you an idea of just how much of what's modern America was controlled by them. And if you take the little inserts up at the top there, you can see how much of the rest of the area west of the Appalachians at one time was under the control of the French, the Spanish, and others. Add to this the presence of Russians, who not only owned and settled Alaska up to Stewart's Folly, but also had settlements along the northern California coast. During all this time and into the 1880s, there were essentially no controls over immigration anywhere along the present borders of the United States. This was also true of much of our border with Mexico well into the pre-World War II era. This is a map of the border in Nogales, Arizona, and Sonora, obviously taken during the 1920s during Prohibition. Do you see much of a wall there? I suspect that a number of people from the north easily walked to the south, and I suspect that all those buildings on the south had bars. As a side note, this discussion omits the consequences of our imperial period. We acquired both the Philippines and Puerto Rico from Spain, bringing under our control former subjects of the Spanish Empire. Immigration from the Orient to the west coast of the United States started with Chinese coming to the gold fields of California and staying on to build much of the West infrastructure, especially its railroads. Many immigrated to the Pacific Northwest, coming not just to cities like Seattle, but also playing a major role working in the fish canneries that lined the lower reaches of the Columbia River. For example, there was a fish cannery in Napton Cove, Washington, that employed 70 Chinese workers in 1876. It later became a quarantine center for immigration at a later point. By and large, the Chinese immigrants were male and lived a segregated life in the gold camps and work camps. Many returned to China from time to time, returning to the United States some years later with a family. Japanese immigrants started coming later during the Meiji era, 1868 to 1912, after Japan opened up to the West. The 1870s census showed 55 Japanese living in the United States, but the numbers increased sharply after that, especially after the United States passed the Chinese Exclusion Act of 1882. Between 1901 and 1908, 127,000 Japanese citizens entered the United States. Most were young men who replaced the Chinese laborers. At that point, the United States and Japan signed what was called a gentleman's agreement. Among other things, Japan agreed it would not issue passports for Japanese citizens planning to work in the United States, in exchange for which the United States would allow immigration of family members from Japan, wives, children, and parents. It remained into effect until the new U.S. Immigration Act of 1924. As a personal note, when I lived in Niigata, Japan in 1967 and 68, the governor of the prefecture was a man who had been a running back for Rutgers in the 1920s. The discussion so far omits any mention of the very large group of involuntary immigrants, slaves from the various parts of Africa, brought into what is now the United States prior to the constitutional ban on importing slaves after 1808. Article 1, Section 8 of the Constitution. I always carry mine with me. To the best of my knowledge, immigration from Africa was irrelevant to our post-independence story of immigration and immigration law, except for one factor, the path to citizenship. The Naturalization Act of 1790 set out the first rule for naturalization and limited eligibility to free white persons. The law and its progeny remained in the books with respect to persons who were not of the black or white races, that is, East Asians, well into the 20th century. This is the basis for the alien land laws enacted by Washington, Oregon, California, and other states, effectively prohibiting first-generation East Asians, with some exceptions, from owning real property. While these laws became irrelevant after post-World War II changes in our immigration laws, as well as unconstitutional, the law in Washington actually remained on the books until 1967. This brings us up to the case of one United States versus Won Kim Ark. Won Kim Ark was born in San Francisco to Chinese citizens who were U.S. residents, but later returned to China. He visited them in China, returned to San Francisco in the early 1890s, and was denied admission based on the Chinese Exclusion Act. The Supreme Court ruled in his favor in a 6-2 decision in 1898, citing the 14th Amendment provision that reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside." The court clarified that the only persons, quote, "not subject to the jurisdiction," unquote, of the United States were diplomats or employees of foreign nations or children born of enemy aliens in hostile occupation. Although the 14th Amendment's primary beneficiaries were, of course, the freed slaves, the court stated that its decision also is based on a long line of British and American common law well recognized at the time of our independence, as well as well understood principles followed prior to the Civil War with respect to whites. A contemporary note, all courts deciding the matter this year have rejected as unconstitutional the recent executive order seeking to ban birthright citizenship for children of non-immigrants. The local judge here, John Kuhnauer, was appointed by Ronald Reagan, and he's old enough to actually live here. And he said, when he asked one of the government lawyers, did any lawyer have any input in that executive order? Enough of the fringes of immigration. Even I recognize that most immigrants through at least World War II entered the United States through our major eastern seaports. That includes Peter Schweitzer, who after being on the losing side of religious wars in Switzerland, sailed from Europe to Philadelphia in the 1760s because of the colony of Pennsylvania's reputation for religious tolerance. The family kept moving west and south, changed their name to Swisher, and eventually settled in an area that looked like home, modern-day West Virginia. Most European immigrants up through the Civil War came from Western and Northern Europe, especially regions near to or with good connections to major seaports. Significant immigration from Eastern Europe and the Mediterranean became major factors primarily after the Civil War. Throughout our history and the entire history of mankind, there's been a steady stream of fear of and prejudice of the other, the person not from our tribe. The story of West Coast prejudice against Asian immigrants is not isolated. The same tendency showed up elsewhere in the United States as newer European immigrants came from backgrounds different from those who got here earlier. These trends grew in the late 19th and early 20th centuries, culminating in the Immigration Act of 1924, the first significant legislation placing limits on immigration from throughout the Eastern Hemisphere. Early in World War I, 1917, Congress enacted the first widely restrictive immigration law directed at Asian immigrants. It also implemented a literacy test. President Wilson blocked legislation that would have set up national quotas. However, the change of administrations in 1921 and a general wave of isolationism that accompanied it led to the revival of the concept. The 1924 Act followed. The 1924 Act set up what was a, quote, rational origins quota system, unquote. The quota system limited the issuance of immigrant visas to 2% of the total number of people of each nationality in the United States as of the 1890 census. It also completely excluded immigrants from Asia, generally that part east of Iran. Why the 1990 census? Because a later census would have set higher quotas for later arrivals who diluted the portion of our population from the earlier sources of immigration, primarily Great Britain. I have no idea how the question of ethnic background appeared in the 1890 census, and I wonder about its accuracy, as by then many Americans had already moved out of their original ethnic shells and become European mongrels. Nevertheless, this was the input into the system. The 1924 Act used the post-World War I map of Europe and the Near East in determining to which country quota an individual seeking to immigrate could be assigned. Anyone with a sense of history of those regions would recognize that these new borders did not reflect clear ethnic lines, or in many cases, anything like the European borders at any time before the war. For example, both Poland and Lithuania grew, shrank, and for a time disappeared from the political maps prior to World War I. And the collapse of the Ottoman Empire left ethnic lines upsetting that region even today. The 1952 Immigration and Naturalization Act retained these same borders in determining immigration quotas. Neither the 1924 Act or its 1952 successor placed any quota limits on immigration from independent countries from the Western Hemisphere, including Canada and Mexico. Also, neither act made any provision for admitting refugees from the Eastern Hemisphere, despite all the people fleeing from the Soviet Union, Hitler's Europe, and the Spanish Civil War. Consequently, many Europeans unable to enter the United States emigrated to Latin America, especially Venezuela, Brazil, and Argentina. When I was a visa officer in the American Embassy in Caracas, I issued immigrant visas to Romanians who had been on the waiting list since 1945 and 1946.
Wow.
In contrast, Cuban refugees in Venezuela could get processed for immigrant visas in a matter of a few months. Among those refugees were the former Minister of Education for the pre-Castro government and his wife and children, including an infant daughter who was soon to retire as president of the University of Washington. In conversations with her over the years, we've discovered that there is a 50% chance I signed her immigrant visa. As an aside, the 1924 Act also had a relatively minor provision for later repealed in 1940 and directed at women. It stipulated that if an American citizen woman married a non-citizen, she would lose her citizenship. The same did not apply to men. I was on temporary assignment to the passport agency in Seattle in 1965 due to a family emergency. On one occasion, I encountered the passport application of a woman born in Ballard, who wanted a passport so that she and her naturalized husband could travel back to the home in Norway. The husband was a Norwegian citizen at the time of their marriage. I had to inform the poor woman that she had lost her citizenship by her marriage in 1928, but hastened to reassure her that if she could get immediately restored if she simply signed a document swearing her allegiance to the United States. I could then issue her passport. The 1924 Act remained in force with modifications until it was replaced by the Immigration and Naturalization Act of 1952 in the middle of the McCarthy era. It passed over a veto by President Truman. More on his reasons will be discussed in the subsequent session. The quota limits were based on the 1920 census, which was a bit of an improvement over the 1891. Again, one may wonder about the accuracy of this census as we have become even more mongrelized. Asian countries got quotas, as did new countries. The quotas for most of the new countries, including newly independent Korea and India, were 100 persons each. And over 94% of the quota numbers still went to Europeans. The UK, Germany, and Ireland alone were assigned nearly 69% of the entire Eastern European quota. There still were no limits for independent countries in the Western Hemisphere. The 1952 Act had elaborate rules for determining the quota for which a person was charged. It had its own set of discriminatory rules. It also set up a framework for allocating immigrant visas within each country quota. It allocated up to 50% to aliens needed urgently in the United States because of high education, technical training, or of exceptional ability or specialized experience. Senator McCarran of Nevada headed the Judiciary Committee, and this category eventually included Basque sheep herders.
Oh, Basque.
Winnemucca, Nevada had some great Basque restaurants when I visited it a few years ago. The law then allocated 30% to parents of U.S. citizens over the age of 21 and 20% to spouses of or children of lawful permanent residents. If a country quota was not used up after issuing visas to the first three categories, it was allocated to other qualified immigrants, including first brothers, sisters, and adult children of U.S. citizens, followed by anyone else. These rules were further refined as the years passed, but there were many people from various countries who had no reasonable chance of immigrating to the United States unless they fell into the upper categories of the quota for their country of origin. I observed the perverse way these rules worked when I was in the embassy in Caracas. I previously mentioned the Romanians who had waited in line since World War II. Also, up to 250,000 Italians had moved to Venezuela in the early post-war years, many of them skilled young single men. They knew there were no quotas for Western Hemisphere countries, and many immediately went to the embassy to register to immigrate, only to find out that the non-quota system only applied to persons born in the hemisphere. Thus, these skilled and able workers, many of whom had family in the United States, could not get immigrant visas, while their equally skilled counterparts born in the Western Hemisphere could expect to immigrate within months after applying. I encountered another anomaly involving a talented Cuban string bass player who had an offer to join Pablo Casals in Puerto Rico. His family included a mother in her 80s born in Spain. She was not eligible for an immigrant visa under the Spanish quota. Fortunately, my excellent boss authorized for her to get a non-immigrant visitor's visa, recognizing she was not about to join the labor force. This system of immigration quotas lasted until the major immigration reforms in 1965. That will be where we start part 2 of the discussion. The 1952 Act had a built-in presumption that every alien entering the United States was a presumed immigrant unless he or she could prove he was entitled to non-immigrant status. The Act had a long list of non-immigrant visa categories, which has been retained in somewhat altered form to the present. With the exception of Canadians and perhaps a few others, at that time all non-immigrants needed a visa to enter the United States. Most came as tourist or on business visas, but the law also created visa categories for diplomats, students, persons coming for exchange programs, certain categories of temporary workers, and members of the press. These categories were further refined in the 1965 and subsequent legislation. The 1952 Act had an extensive list of 32 classes of ineligible persons for visas or admission. 6 were medical-based. Several provisions related to criminal or moral grounds of ineligibility. A few others were designed to call out the most needy, just the sort of people Emma Lazarus mentioned in her poem. Nearly half of the space was devoted to just 3 sections, all related to national security, especially number 28 related to anarchists and communists that ran on and on and on in explicit detail. I had not originally planned to discuss the other side of immigration laws, deportation, but now find it inescapable. The 1952 Act set out various grounds for deportation, most of them irrelevant to this discussion. However, it did have several related to security, some of which I'm only learning about in the papers these days. All related to national security, especially number 28 related to anarchists and communists that ran on, The state of, leading most of this discussion for later, I'd like to discuss the focus on one incident as it played out in Seattle at that time. The state of Washington had the equivalent of the McCarthy Committee deliberations in the early 1950s. It was the Canwell Committee, headed by a senator from Spokane. Among other activities, it conducted hearings to ferret out alleged communists on the University of Washington faculty. The committee issued subpoenas to faculty members who were suspected of being or having been communists or communist sympathizers, as broadly defined in the law. One of the faculty members receiving a subpoena was a professor from Spain in the Romance Language Department, whose chairman later became my father-in-law. The professor had been on the losing side of the Spanish Civil War and feared that that fact could result in his deportation to Franco Spain. My wife remembered when the professor had dinner at her parents' house the night before he was scheduled to testify. He then checked into a top-floor room at the Olympic Hotel and committed suicide. A final note on Western Hemisphere immigration prior to 1965. The most significant demand for immigration from the Western Hemisphere came from 2 countries originally, Mexico and Cuba. We followed policies in Mexico that discouraged legal immigration. For example, we limited the issuance of immigrant visas to the embassy in Mexico City and only the consulates in major cities, Guadalajara and Monterrey, plus 2 border cities on the Rio Grande and Tijuana. Many of the other countries, especially the nearby countries of Central America and Venezuela, had relatively sparse populations compared to the present. There was slight pressure for economic or political immigration from these countries compared to the ensuing pressure for years of rapid population growth, relatively stagnant economies, and political stability and repression. We operated under the above system of immigration law until major reforms substantially altered the structure of immigration and immigration policy, starting with the Immigration and Nationality Act of 1965, followed by the Refugee Act of 1980. Many of those persons wanting to make America great again seem to look back with blurred vision and nostalgia to the pre-1965 world, favoring immigration from Eastern Hemisphere only from people from the right ethnic background. Part 2 next week, if I get my act together, we'll look at those changes, the impact they have made, and some of the ramifications that follow.
Questions?
I also have the impression that these immigration acts don't actually reflect very closely what actual immigration occurs. There's lots of people from Canada who just came across the border into the U.S. when the border wasn't very well observed. There were people, I know from looking at ship records from the 1910 that people got off ships and never went back to China or Japan.
Yeah.
And I know that in Europe, prior to the war, because of the attitudes of the U.S. representatives there, that some of the quotas were undersubscribed because they just didn't want to honor them. So what portion of our population, or our immigrant population, is actually I shouldn't say legal, but an actual representation of real immigration?
That's a very good question, especially on the borders. I had an aunt by marriage who lived in Santa Ana in an area that had become highly Hispanic. One of her friends said, "Why do you still live in that area with all those white wetbacks?" She said, "I was a Manitoban wetback."
So my great-grandparents entered the United States around 1900 from Ukraine, I believe, or what was probably called the Pale of Settlement then, and there was a big Eastern European immigration of Jews then. And what I'm wondering is, under what auspices did they enter the United States? What was the legal auspices of their...
What year was that? What year?
1900.
We didn't have any quotas at that time.
Okay, no quotas?
No.
Anybody who wanted to come could just show up at Ellis
basically,
Island, get
yeah.
a new name, and become...
You didn't even have to be literate at that point.
I think they probably weren't.
Following up on that, in the 1930s, many Jews who wanted to emigrate from Europe due to the Nazification, in particular in Germany, were denied the ability to immigrate to the U.S. What was the status of the immigration law that made that possible at the time?
In 1930, we had the 1924 Act. If they were Germans, born in Germany, they should have been able to get visas within the quota limit, whatever that was at that point. Of course, getting your documents out of the Hitler government was quite difficult. I had a friend who was able to do that, and he escaped from Germany via the Soviet Union.
So frying pan to the fire?
Well, we're looking forward to hearing part 2. Why don't you move the next slide? And
Oh, I forgot that
this
one.
is, yeah,
Yeah, that is relevant to next week.
yeah. Yeah, Truman tried to get rid of this one and Congress, they had a vote overriding his veto. Okay, if no one else has any more comments, thank you very
Nothing
much.
over there.
Very enlightening.
Comment there.
Oh, I'm sorry.
We need you to talk into this so we can
I
hear
would
you.
like a little explanation of that very concise paragraph that you're ending with. It looks like there's a lot in that. Maybe that's for next week, eh?
Yeah, I start with Truman at that point.
Yeah, that's a headline I actually copied off the New York Times of June 28, 1952. Okay. More on that next week. All right. And, do we have another? All right. Thanks again. See you next week.